the Supreme Court that's entered day 3 of its hearing on a bunch of petitions regarding the demand for marriage equality in India. Hearing the plea on same-sex marriages, the Chief Justice of India today has gone on to say that decriminalizing homosexuality through the 2018 Navtej Johar judgment, same-sex relationships were recognized as having the potential to be stable. Earlier, he had also said that there's no data from the government that that's the same-sex marriage is urban or elitist. A 5-judge bench headed by the Chief Justice is being heard in the Supreme Court since Tuesday, and the hearings will continue on Monday as well.
So you're really asking us to read into the statute the expression spouses for really man and woman.
So does the underlying thrust of SMA exclude your lordship's reading or insertion or understanding of that construct?
Because your principal premise is that when the legislation was enacted in 1954,
yes,
the object of the legislation was to provide a form of matrimony for people who are not falling back on their personal law of marriage.
Absolutely.
Right?
And special categories.
You are giving Parliament was intending to provide an avenue to people beyond your religious, the religious governance of marriage, so to speak.
Yeah. There was also an aspect of endogamy.
Yeah.
Yes. There was an aspect of endogamy which we cannot ignore.
Yes.
So it was an all-enfolding kind of a legislation.
And it cut across so many spectrum because it was intended to be a very special category.
After 1954, in the last 69 years, our law has really evolved to recognize the fact when you decriminalize homosexuality, you also realize, well, these are not just one-off relationships. This also comprehends a stable relationship.
That's because you go back and say,
by decriminalizing homosexuality, we have not just recognized fleeting relationships between consenting adults of the same gender, right? We have also recognized implicitly, therefore, the fact that people who are of the same sex would be in stable relationships. Now, the object of the law in 1954 was to bring in its fold people who would be governed by a matrimonial relationship apart from their personal law. And surely that law is capable of being broadly read according to you, so as to take into account more stable relationships.
Let me put it bluntly.
The same sex as well.
Let me put it bluntly. When you enacted the law, you did not, in the debate in Parliament, in the writing of the draftsman, when I get up and speak on it, may not have got homosexuals in mind. You may not have considered them.
That makes no difference.
The way which you are perhaps propounding is, this provided a framework, but that framework is of the concept of marriage. The concept of marriage transcends contemporary understanding to
it's an evolving dynamic concept.
To comprehend an evolving idea
dynamic, very dynamic.
Looking at India constitutionally and socially as well,
yes,
we have already reached the intermediate stage, right? The intermediate stage postulates that by decriminalizing homosexuality, your very act of decriminalizing homosexuality does contemplate that therefore people who belong to the same sex would be in stable marriage-like relationships.
Marriage-like is the operative word.
Right, marriage-like relationships.
Live together.
Because the moment we have said that it's no longer an offense under Section 377, therefore we necessarily contemplate that you could have a stable marriage-like relationship between two persons who do not treat these as chance encounters, but as something more than that, not just a physical relationship, but something more of a stable emotional relationship, right?
Societal.
Which now is an incident of our constitutional interpretation.